Good evening, class. So today we are going to finish off Prospectus, Chapter 3 of Companies Act. Name of the chapter is Prospectus and Allotment of Securities. And let me tell you, we have covered Prospectus, we are on to Allotment of Securities today. So this chapter, which is known as Chapter 3 of Companies Act 2013, we have or we will see that this chapter is one of the most important chapters of Companies Act in your syllabus because it covers almost 20 sections, starting from section 23 to 42. Out of that, I'm just quick revising what we have done and what we haven't. Out of that, section 23 to 33 deals with prospectus general provisions. 34 to 38 deals with punishments or penal provisions for misstatement in prospectus. And the third section which we will cover today, which was left, section 39 to 42, deals with allotment of securities. So we have done these two sections, we are yet to do this one today. And alongside this, we will also do some past paper questions. That's the agenda for the day. Let us quickly start. Prior to that, I want to revise with you once what we have covered in the first two classes. In the first class itself, I told you what is misstatement. What is misstatement in a prospectus? I said any false statement and any non-disclosure, false statement or untrue statement and any non-disclosure of facts both amount to misstatement, and for misstatement in prospectus there are many types of liability. The first liability is known as civil liability or criminal. The criminal liability for misstatement in a prospectus is given by section 34, whereby it is being said that any misstatement in prospectus amounts to a criminal offense as per Code of Criminal Procedure. The company will have to be fined under section 447. And who will be exactly fined? The persons who authorize the issue of such prospectus. All the persons. Only two exceptional situations were covered, whereby we had seen that had the misstatement not been material enough, silly mistake kind of a thing, then you can be pardoned, or the second case where the person can prove his innocence by saying that it was not known to him. He believed it to be true till the date of issue of such prospectus. So after that we had done section 35, which deals with civil liability of misstatement in prospectus. In civil liability we saw there are five types of persons, and also the company both will be liable to the person to any person or group of persons to whom prospectus has been issued, and based on that prospectus they have subscribed to the shares of a company. And not only that, we have also seen that in such a case where shares are issued, Ganesh, ye off karke ye chala dijiye. So we have seen that as per section 35, incurrence of loss based on investments done on based on reading of prospectus, then only we can claim a damage under section 35, and the company will be liable to pay to the person who has suffered such losses. Clear? And then after that we have done section 36, which was directly fraud. Then we have done section 37, which was nothing but enabling provision, which was enabling the people or investors to file a lawsuit under section 34, 5 or 6. Then last section was section 38, where personation, where a person is personating a false identity, assuming a false identity and applying for the shares of the company, and here the punishment is on the company or the investor, on such investor. Section 447 once again. After that, we have seen section 23, which was talking about types of issue. A private limited company can do right issue or, increase its share capital by way of right issue or bonus issue or private placement. A public limited company can do in all these ways plus public offer. Public offer, which is IPO or FPO. Okay, section 24 was talking about powers of SEBI. If you recall, Companies Act is empowering SEBI to make laws or make, rules in regard to two things. One is transfer of securities, issue transfer of securities, and the other one was non-payment of dividend. Any other law shall be administered by central government. Okay. Then section 25 read with 28 was talking about deemed prospectus and offer for sale, if you recall. Then we have done other types of prospectus like shelf prospectus, which has a shelf life of 1 year. Then we have done red herring prospectus section 32, which is talking about that, in a prospectus certain details will be missing as to the quantity of shares to be offered and the price at which issue price. Under book building process, it will be determined. And once it is determined, the final prospectus will be prepared and filed. In shelf prospectus, the shelf life of a prospectus is maximum for 12 months from the date of issue. And any subsequent issue has to be issued with the help of information memorandum, which will contain all the changes from the date of issue of shelf prospectus till the date of issue of the next security. Are you getting me? And lastly, we have done average prospectus section 33. That is a small, in a nutshell, the entire information in a prospectus, all the relevant ones will be abridged, shortened, and issued to all the investors along with the share application form. Recall? Okay. And not only that, we have done many other small topics like section 26. 26 was what? Contents of a prospectus, 3 types of information: general information, statutory information, right? And we have also done section 27, variation in the object clause. That is, if a company has written that it wants to utilize the funds for a certain purpose and it is changing the, yes. If it has got surplus funds, can it invest in any other project other than what is written or mentioned in the prospectus? No. For that, how will it do so? It will pass yes. And also it will give a exit option to dissenting holders. Getting me? Not only that, section 29 and section 30 was advertisement of prospectus. In advertisement of prospectus, 3 things needs to be mentioned. The memorandum details like the object, the share capital amount, right? And the the type of liability, first point. Second point was signatories, right? And third point was capital structure. Recall? Okay? All these things we have seen. Now we are on to section 39. So, in order to help you recapitulate, we will go through the slides with a 10 seconds delay so that we can all revise what has happened. If you recall, this was misstatement. Okay, commission or omission, both are misstatement. If you recall, civil liability was section 35 and criminal liability was section 34. Section 34, criminal liability for misstatement in prospectus. 2 exceptions. Civil liability for misstatement in prospectus, the 5 persons, director, promoter, team director. Are you getting me? Then exceptions of civil liability. Then punishment for fraudulently inducing person to invest money, section 36, 447 will be applicable here also. Then 37, action by affected persons. enabling provision, which enables the affected persons to take legal course of action. Then we have section 38, punishment for personation. Recall? Then we have section 30, meaning of fraud, and meaning of 447. Of course, 447 is talking about two things. One is imprisonment plus fine. Public offer and private placement, this was section 23. Recall? Then after 23, this was 24. Issue and transfer of shares and non-payment of dividend for listed companies and companies intending to get it listed will be governed by SEBI. Powers are given to SEBI. Any other case, central government. Matters of prospectus, general information, financial and statutory. Then we have seen the punishments for non-compliance of with the contents of prospectus. Then company shall be fined for a amount of 50,000 to 3 lakhs, and every director in default up to 3 years fine and both fine and imprisonment. Then other requirements, 90 days before the issue you have to register the prospectus with the ROC with the consent of all the persons named in the prospectus. Then public offer for securities to be dematerialized form. Of course, I have talked about dematerialized form, demat account. Then section 25, which was deemed prospectus and offered to sale, if you recall. Okay. And then variation in terms of contract or objects in prospectus. Then advertisement in prospectus, see the 3 items. Section 30, we just revised. Yes or no? Then section 31, shelf prospectus. Then section 32, red herring prospectus. And then section 33, abridged prospectus. And here on we begin our topic of the day, which is allotment of securities by a company. Okay, let us start. The test which I said I'll take, I cannot today because no point. So it will be any day on this week, either Monday or Wednesday or Friday. I'll write it on the group. If I declare, sometimes you are backing out or maybe you are feeling. So be prepared by the weekend and we'll give it any day on Monday or Wednesday or Friday. Okay. Because Monday is the submission date. Okay. Okay. I get it. No worries. So Monday, you're not sure, but you can, yeah, good that you said. So what is allotment of security? What is allotment of securities? When we talk about share allotment of securities allotment, we think of the capital which is yet to be subscribed or already subscribed. Yet to be subscribed. We can only offer to public the capital which is yet to be subscribed, that is unsubscribed share capital. Unsubscribed share capital, or we can also call it better name, sorry for the wrong name, the better name, the improvised name is unissued share capital. The share capital which has not been issued, unissued share capital. For instance, a company has authorized share capital of 10 crores, it has only issued 5 crores, so its unissued share capital will be 5 crores. And out of that 5 crores which is unissued yet authorized, the company can issue up to 5 crores only. Okay, and once the company issues and public, subscribes for it, then the company will have to allot it to the public. That is allotment of securities. Are you getting it? Are you getting it? Let us read through the language, then from the language itself you can make notes. Allotment means appropriation out of previously appropriated or unappropriated? Unappropriated capital of the company. Okay, so appropriation out of unappropriated capital of a company. Write down meaning of allotment: appropriation out of previously unappropriated capital. Appropriation out of previously unappropriated capital. Appropriation out of previously unappropriated capital of a company. Clear? Is it clear? Okay? All right. So, the next thing. Let us talk about the next thing. Till such allotment of shares do not exist as such, it is an allotment that the shares come into existence. Of course, before allotment will the shares exist? No. Only after allotment the shares exist and can be traded. Yes or no? So that is allotment of securities. Now, in allotment of securities, we have many legal framework. I will explain to you on whiteboard, then you will copy, and then we will go to the text of the PPT. First, you've heard of a thing called minimum subscription. What is this? Let me tell you, Companies Act 2013 is silent about minimum subscription. It is not by Companies Act 2013. Companies Act 2013 states minimum subscription shall be as prescribed in the articles. As prescribed in articles. So it is saying see articles or referred articles. But if we talk about SEBI Act, then SEBI says 90% of the entire issued share capital shall be subscribed, or else you have to refund all the money collected on subscription. Are you getting it? So 90% minimum subscription is a mandate given by Companies Act or SEBI? SEBI. A lot of people don't know. Are you getting me? So SEBI asks you to, that if you're a good company, then 90% of your entire issue shall be subscribed by the public. If it is not, then you refund the money and you start, once again. So this minimum subscription could be either in the articles, whether or not in the articles it cannot be lesser than 90%, because for companies which are under SEBI, it has to be 90%. Okay, and any company issuing to public will have to abide by this. Are you getting me? Second, we have also heard of another thing called minimum application money. Minimum application money. Okay, any idea? This also, it was there in CPT, CA Foundation, and now once again I am raising this issue because this is of course there in Companies Act and also SEBI Act. So can you tell me, minimum application money, what we have read while doing CA Foundation maths was 5% of nominal value of the share capital. Companies Act 2013 states 5% of NV. NV is what? Nominal value of or face value of share. Don't you think nominal value of an equity share is rupees 10 and 5% of rupees 10 is not even rupee 1? 50 paise. So you can understand how nominal it is. It is no big deal and it is negligible and it is as good as nil. Are you getting me? But in real life there's SEBI also, and SEBI mandates that this is very low and minimum application money should be 25% of the issue price. Now it makes all the difference because issue price is much bigger and much larger than the nominal value. So and in application you have to pay minimum how much? Minimum 25% of the issue price.
Issue price includes securities we issue.
Of course, issue price is the price at which a security is issued. Okay? Alright? Nominal value is the face value of the security. Okay? So both are different values and the percentage is also differing. Are you getting me? So SEBI is correcting the negligibility of Companies Act. Is it clear? This is given by section 39 of Companies Act 2013. Okay, please copy, no worries. Okay, now let us talk about how the securities, after getting allotted, how the management will happen. After people apply for the securities by paying the application money, and after minimum subscription is received by the company can allot the securities. But before allotting the securities, when the company receives the money, the company keeps the money in a bank account. It has to be a separate bank account with a scheduled bank, and such a requirement of a separate bank account with a scheduled bank is known as escrow account. If you haven't heard of this term, you will hear it going forward. Escrow account. Escrow account is nothing but a special bank account created or opened for a special purpose, and no money can be withdrawn. No money can be withdrawn from such a bank account, other than the stated objectives. Tell me, won't your money be secured? Won't your money be secured if you're keeping the money in an escrow account and the objectives are stated? You can only withdraw the money in the when you require it. When you require it for which purpose? For the purpose for which you are issuing the securities. For instance, the only objective of application money could be allotment of securities. Against the application money received, you will allot the securities, or it could be refund. If it is a failed subscription, then there could be refund. So escrow account can be utilized with regard to allotment of securities. Escrow account can be utilized only for twin objectives, only for two objectives. Number one, if you want to allot the securities against the application money, then you can utilize the application money. Or number two, if you want to refund. Are you getting me? So the twin objectives for escrow account for allotment is, number one, if you want to allotment of the securities, And number 2, refund. Is it clear? Okay? All right. So, next let us talk about underwriting of securities. Of course, these are common topics with accounts. Underwriting of securities. Okay. In order to ensure that our issue doesn't fail due to lack of minimum subscription, most of the companies go for an underwriting agreement with an underwriter. And what is an underwriting agreement? Underwriting agreement is an agreement whereby the underwriter undertakes to subscribe to the unsubscribed shares of the company. Are you getting me? So underwriting agreement is an agreement whereby the underwriter is undertaking or promising the company that it will subscribe to all the unsubscribed share capital of the company, if any. Okay? And for which they will be entitled to an underwriting commission. Yes or no? And that underwriting commission cannot exceed in case of a share, and in case of a debenture, so underwriting commission shall be lesser of the following. Number 1, number 1 will be limit prescribed in Companies Act, Section 40. For share, it is 5% of the issue price. Okay? And for debenture, it is 2.5% of issue price. Is it clear? And number 2, it has to be lesser of the following 2. Limit prescribed as per articles. Prescribed as per articles. Are you getting it? So, it cannot be more than 5% or 2.5% because this is the limit, maximum limit allowed in the Companies Act. But it can be lower than this. It cannot be higher than this, but it can be lower amount if the lower amount is prescribed in the articles of the company. Are you getting it? This is a very important learning because they ask you questions from all these points, especially underwriting commission. Is it clear? Okay. Now, I guess that takes care of most of the portions of section 39 and 40, apart from number of days within which money has to be refunded, number of days within which allotment has to be made, which we will cover in the slides itself. Okay? So let us come to the slide for allotment of securities and understand what is there. No allotment of any security of a company offered to public for subscription shall be made unless the amount stated in the prospectus as minimum amount of subscription has been subscribed, and all sums payable for application for the amount so stated have been paid to and received by the company by check or other instrument. Minimum application money. The above was minimum subscription. Now minimum application money is 5% of the face value. I told you, as per Companies Act. And as per SEBI, it is 25% of issue price. Are you getting me? Then if the stated minimum amount has not been subscribed, the sum payable shall be refunded within 30 days of date of issue of prospectus. Okay? So, sorry, I'm wrong. If the amount is not received within 30 days of, date of issue of prospectus, then the amount shall be refunded. And the time limit for refund is 15 days. 15 days from the date of closure of issue. We'll come to it. It's written. Don't worry.
The delay in prospectus issue, 30 days, and then 15 days. These are the two parameters.
Is it clear? So if within 30 days of date of issue of prospectus, if the money of, money of minimum subscription is not received, then within 15 days from what? Listen, 15 days from this. This is what? Date of closure of issue. Date of closure of issue. Within 15 days from date of closure of issue, you have to refund the money. Clear? Is it clear? This is the funda. Okay, now let us come back to the, you copy first. Okay, all right. Now let us come back to where we were. See, if the stated minimum amount has not been subscribed, or the sum payable on application is not received, both, either or, within what? 30 days from date of issue of prospectus, the amount shall be returned within such time and manner as may be prescribed. This is prescribed later on. Whenever a company having a share capital makes an allotment of securities, it shall file with registrar a return of allotment. Very important. You have to file with the registrar a return of allotment. Okay, return on allotment. Okay, in case any default under subsection 3 or 4, the company and its officer who shall be default, penalty will be 1000 rupees. Listen to me, penalty will be 1000 rupees every day of continuing default, 1000 per day. And in case it is exceeding 1 lakh, then it will be 1 lakh, whichever is higher basically. So this is the summary. Allotment of securities by company. Minimum amount subscribed and application money has been paid and received by the company. Application money shall not be less than 5% or 25% of issue price as per SEBI. Okay, minimum amount not subscribed and application money not received within 30 days of issue of prospectus. Are you getting me? Or such other period as may be prescribed by SEBI. Of course, you need not know it because SEBI law is not there. Amount received shall be returned within 15 days of closure of issue. That's why I told you closure of issue se 15 din ke andar. Where company makes an allotment of securities shall file allotment with return of allotment with registrar, and the penalty is 1 lakh or rupees 1000 per day, whichever is less. Is it clear? The entire allotment slide. Okay. Now go through this. Once the securities are issued and subscribed for, these needs to be allotted in tune with the conditions as given below. Minimum subscription, of course you know, within 30 days. In case minimum subscription is not received, the issue is regarded as failed, and basically the entire money shall be refunded along with applicable interest, if any. So you have to pay interest if you're delaying, because you have to pay within 15 days. Got it? Okay. So application money has to be more than equal to how much? 5% of the nominal value. Okay. Now let's come to section 40. Section 40 also we have done. Escrow account is a part of section 40, and underwriting commission is also a part of section 40 of Companies Act. Okay. Filing of an application with recognized stock exchange. Okay. When a company intends, tell me, when a company intends to get listed in a stock exchange, then in that case the company has to do listing, enter into a listing agreement with a stock exchange, and it has to be a recognized stock exchange. There are round about 24 stock exchanges recognized, okay, by SEBI. So in these stock exchanges, in any one or more of the stock exchanges, you have to apply for listing of your securities, listing of not company but the securities of the company. Okay, that's the procedure. So filing of an application with a recognized stock exchange is being said by section 40. Every company making public offers shall, before making such an offer, make an application to one or more of the recognized stock exchanges and obtain permission for the securities to be dealt with in such stock exchange or exchanges. Can a company list itself with more than one stock exchange? Of course, ITC. ITC is listed in Calcutta Stock Exchange, Bombay Stock Exchange and National Stock Exchange. So there are many such companies which are listed in multiple stock exchanges. Okay. Prospectus to state the name of stock exchange also. In the prospectus you have to mention the name of stock exchange. Of course, in contents of prospectus section 26 also we have dealt with the same. Okay. Now, to maintain a separate bank account, ये मैं बहुत पहले पढ़ा चुका हूँ आज ही. Escrow account एक बार देखो, language पूरा same होगा. All monies received on application from the public for subscription to securities shall be kept in a separate bank account in a scheduled bank and shall not be utilized for any purpose other than two purposes are there without seeing. Number one was adjustment against allotment of securities. Number two was refund. Okay, for repayment of the monies within prescribed time. Clear? So these are the only two purposes for which you can touch your escrow account or separate bank account with a scheduled bank maintained for the purposes of allotment. Is it clear? Okay. Now let us come to the last part of this section, big section it is, which is default. Let me know if there's any default in section 40, not 39. 40's default is another, 39's default we have seen. 1 lakh or 1,000 per day, whichever is less. So in 40, where you fail to, register yourself with a recognized stock exchange, where you fail to mention the name of the stock exchange, where you fail to maintain a separate bank account, the crime is bigger. And the punishment is also bigger. See, company fine varying from 5 lakh to 10 times, which is 50 lakhs. Companies Act 2013 is extremely stringent, and every officer will be punishable up to 1 year or with a fine of 50,000 to 3 lakh or with both. Is it clear? This section 40, not 39, to be marked. Now the last thing which I explained was underwriting commission, which is also there in accounts. What is the figure for underwriting commission? Any 5% for shares. 5% of what? Issue price? Yes, not nominal value. 5% of issue price of shares, it cannot exceed. It cannot exceed. So the articles can prescribe for a lower number, not a higher number. In case of debentures, it's exactly the half. Half of 5% is 2.5%. Okay. Now, let us come to GDR. The next topic is GDR. Section 41. Okay, let us think about it. What are GDRs? Suppose Reliance is a company. Of course it is. It wants to tap the securities market outside India. It wants to bring in some foreign investments. Now there is a route called FDI, foreign direct investment. It's a big route. So recently Reliance has only sold its considerable stake to a foreign company, a big company known as Aramco, a Saudi company, okay, which suffered an accident also a few days back. So the idea is FDI is a route of foreign investment. Apart from that, can a company which is listed in Indian stock exchange go and list itself in a foreign stock exchange? Not directly. It cannot directly list its securities in a foreign stock exchange, but it has an alternative way. Now that alternative way I am going to describe in detail, and then we are going to come back to this topic called GDR. Okay? Let us understand. Let's say Reliance is giving its securities, issuing its securities and giving it to a depository. Now who is a depository? I explained to you in the class, I was explaining dematerialized form of securities. So depository could be NSDL or CDSL. There are two depositories in India. So Reliance India Limited is giving its securities to a depository and also entering into a contract with a domestic custodian bank. With a domestic custodian bank. Okay. Now the domestic custodian bank and the depository has its securities issued by Reliance. Now the domestic custodian bank is, let's say the name of the bank is Citibank. It's an American bank, Okay. Now Citibank has an office in New York. Citibank is contacting its overseas branch in New York and asking them what? Asking them to issue certain depository receipts. Certain what? Depository receipts. To what? In where? In the New York market. In the New York market. Okay. So it is issuing depository receipts in the New York market, which is getting, it is kind of a security depository receipts, which is getting listed in which market? Stock exchange? New York Stock Exchange, which we know as NYSE. Okay. So it's like a circle. Firstly, the Indian company is basically issuing its securities and keeping it with depository. It's issuing the security, it's depositing the security in the physical format with the depository, and it's issuing the security to the bank. Which bank? Domestic custodian bank. Listen to me. And the domestic custodian bank against such securities is issuing depository receipts, DR. Okay. which is actually known as Global Depository Receipts. That's why we call it GDR. So the domestic bank is in turn issuing the Global Depository Receipts via its overseas branch in New York. Are you getting me? And the overseas branch in any foreign destination will get these depository receipts in a foreign stock exchange, let's say NYSE or London Stock Exchange or NASDAQ or DAX, wherever. Okay, so you have to just imagine the process. So क्या हो रहा है, Indian company अपना securities shares, let's say shares particular denomination का, let's say 5,000 करोड़ का shares, okay, किसको दिया, डिपॉजिटरी के पास फिजिकली रखा, और ये किसका नाम पे बनाया, डोमेस्टिक कस्टोडियन बैंक. डोमेस्टिक कस्टोडियन बैंक क्या किया, इसके खिलाफ 5,000 करोड़ का वैल्यू का फॉरेन एक्सचेंज रेट देख के इक्विवेलेंट अमाउंट का क्या इशू किया, डिपॉजिटरी रिसीट्स. और ये डिपॉजिटरी रिसीट्स उन्होंने इशू किया किसके जरिए, ओवरसीज बैंक के जरिए जो फॉरेन ब्रांच में है. ओके, एंड वहां पे डिपॉजिटरी रिसीट्स अगर वो लोग इक्विवेलेंट अमाउंट का इशू करता है थ्रू देयर स्टॉक एक्सचेंज, पीपल विल सब्सक्राइब और नॉट सब्सक्राइब, एंड द डिपॉजिटरी रिसीट होल्डर्स हैव द सेम राइट एसेंशियली ऑफ दैट ऑफ द शेयर होल्डर्स. हाउ विल दे हैव वोटिंग राइट्स, डिविडेंड राइट तो ठीक है बैंक में मिल जाएगा, वोटिंग राइट्स कैसे मिलेगा, voting rights they will exercise, they will do their votes or give their votes or cast their votes with the overseas bank, and the overseas bank will give it to the DCB, domestic custodian bank, and domestic custodian bank will give it to Reliance. Now you get it. So this is the process of issue of depository receipts which helps us tap in foreign funds. तो कोई इंडियन कंपनी अगर बाहर का मार्केट में इशू करेगा तो वो दो तरह का डिपॉजिटरी रिसीट इशू कर सकता है. एक का नाम है जीडीआर, ग्लोबल डिपॉजिटरी रिसीट, और दूसरे का नाम है एडीआर, अमेरिकन डिपॉजिटरी रिसीट. सिमिलरली देयर आर कंपनीज फ्रॉम अब्रॉड विच वांट टू इन्वेस्ट इन इंडिया indirectly, sorry, not invest, they want to draw money from India. They want Indians to invest in it. They will issue what? IDR. Just the reverse logic. Indian Depository Receipt. So that is the overview on depository receipt. And in Companies Act 2013, interestingly, only Global Depository Receipt has been mentioned in section 41. Is it clear? Totally. It's a very important concept. Okay, so let us come to the slide. First you copy and then copy the word. Clear? Can we go to the slide? हाँ, copy कर लो. Okay. Now, let's come to GDR's write-up. GDRs are issued to broad-base the investor pool and to take advantage of which opportunity or appetite? International investment opportunities. Securities are offered to which? Depository, which in turn issue depository receipts to international investors. These receipts are traded in the international stock exchanges like NYSE. I was explaining through an example. Okay, now the second thing is conditions. What are the conditions as per section 41 to issue depository receipt? Before anything happens, you need to pass a board resolution, BR. After passing of board resolution, you need to hold a general meeting and you need to get the approval of which kind of approval of shareholders, special or ordinary? Special, very good. Depository receipt shall be issued by overseas depository bank. I told you because overseas depository bank is in the foreign country. The depository receipt shall be issued by ODB appointed by company and underlying shares are to be kept in the custody of which bank? Domestic Custodian Bank, DCB. Okay. Now compliance with all the provisions, schemes and regulations of the GDR issue must be met, duly met. And these are issued by whom? RBI. RBI issues all the compliances or provisions and schemes and regulations for issue of such things overseas. Okay, so this is the entire idea of GDR conditions. Once again, passing of board resolution, special resolution by shareholders, then the shares will be issued to the depository receipts will be issued by overseas depository bank, ODB, and the equivalent shares in Indian rupee will be issued to whom and will be in custody of domestic custodian bank. इसलिए नाम ही है custodian bank. Okay, and then DCB, and then you need to comply with all the provisions, schemes made in this regard, regulations made in this regard by RBI. Okay, all right. Now this compliance report, whether you have complied with all the compliances, regulations, provisions made under the scheme by RBI, you will have to place this at the meeting subsequent to issue. Okay, compliance report, and based on this compliance report people will see. Now I said these holders of GDR, are they entitled to vote? It's a very big question which some people overlook. Okay, they are entitled to vote, I said, and they are also entitled to, yes, dividend. So they have the same rights essentially as the shareholders, that is right to receive dividend and right to vote. See, the provisions of the Act and rules related to public issue of shares or debentures shall not apply to issue of GDR. The offered document for GDR will not be considered as prospectus. But point number 3, notwithstanding anything contained under section 88 until redemption of depository receipts, the name of overseas depository bank shall be entered in the register of members. Which bank? Domestic custodian or overseas depository? Overseas depository. Hence, overseas depository bank has a right to vote or not a right to vote? Right to vote. And in turn, it's an interpretation. Since their name is there under section 88 in the register of members, so they are members of the company and they shall be entitled to right to vote and right to dividend. Is it clear? Right. Right to vote, right to appoint a proxy is not applicable because they can, but how will they send a person? Do you think it's cost effective to send a person from New York? Okay, so of course they will apply the rights judiciously with incurring less cost. Okay, private placement, offer or invitation, that is the last topic of this entire chapter 3, which is PP or private placement or section 42. First let us whiteboard and then we will see the slide. It's a very important section, mind you, section 42. It's known as private placement. Last section of this entire big chapter 3. What is private placement? Let us think of it. There's this company. This company wants to issue shares. Now, it doesn't want to issue shares to public because issuing shares to public has a lot of cost and a lot of time involved and a lot of compliances too. Ain't it so? So it wants to simply issue shares to a group of high net worth individuals, or to a group of venture capitalist funds, or to a group of angel investors. You have heard all this term in my class only. Okay. So company wants to issue to a group of HNIs, some venture capital funds, some mutual funds also, or some, angel investors, PI. And in order to issue shares, the first step should be they shall give something like an offer document which is known as prospectus, but we don't call prospectus here, we call it PPOL. What is PPOL? Private Placement Offer Letter. So the step 1 is they will give a private placement offer letter as an invitation to offer to these people. To what? To apply for the shares of the company. Are you getting me? That is step 1. Now, after getting lucrated or attracted, if these people, they want to apply to the shares of the company, they want to apply to the shares of the company, they will pay money, application money. Yes or no? So step 2 is money from the people, and step 3 is allotment of securities under private placement. Step 3 is allotment of securities under private placement. Is it clear? Is it clear, the entire steps? So I said very easily, step 1 is a private placement offer letter will be issued, and step 2 is money will be received by the company from these people, and step 3 is the company will allot its securities to these people. Now in this entire steps, there are a lot of other procedures and conditions to be kept. Tell me, private placement is easy or tough because you're placing it to certain people and not the public at large? It's a special offer or a general offer from Contract Act's perspective? Special offer, so special conditions has to be there. Condition number 1 to be made under private placement is that you will have to pass which kind of resolution? What do you think? Special resolution. There has to be a special resolution. Okay, approving the private placement. Number 2, condition number 2, tell me, can you in a year offer private securities under private placement to more than 200 members, because the name is private? So in private limited company also maximum number of members is 200, and here also, since it's a private placement, the maximum number of members or persons you can apply to is 200 in a year, maximum 200 in a year. So throughout the year you can maximum place it with 200 people. Clear? So maximum 200 persons in a year, less than equal to 200, that is. Are you getting me? Okay. Last condition. Condition number 3. Condition number 3, let us focus. Condition number 3, they are saying, just imagine first, in a private placement, the amount, raised by a company is from the public or from a, small group? From a small group, less than 200. Okay. Maximum less than equal to 200. So since it's a small group you will be raising money from, can each person subscribe for less amount, or each person will have to subscribe for more amount? More amount. Exactly greater than equal to 20,000. Minimum subscription shall be greater than equal to 20,000 face value. Okay, face value अगर 20,000 है तो issue price तो बहुत ज़्यादा होगा. So minimum application size has to be greater than equal to 20,000 rupees per person. Is it clear? So number one, you have to pass a special resolution. Number two, maximum 200 persons in a year you can apply to. And number three, minimum application size has to be greater than equal to 20,000 rupees per person. Is it clear? Is it clear? Okay. Okay, now we go ahead and do the next thing. What is the next thing? The next thing is the write-up in the slide. Okay, private placement offer or invitation for subscription of securities on private placement section 42. Private placement means any offer of securities or invitation to subscribe securities to a select group of person, keyword, by a company other than way of public offer through issue of a private placement offer letter which satisfies the below conditions. Very good. So come to the below conditions. Requirements of invitation for subscription of securities on private placement. Issue of private placement offer letter. Number one. Offer on invitation to number of person maximum how many? 200 year. Offer on invitation treated as public offer only. So private placement offer letter is as good as a prospectus we've read. Payment of amount. All monies payable towards subscription under this section shall be paid through a check or demand draft. That's okay. Time for allotment of securities. Company making offer or invitation under this section shall allot the securities within 60 days from the date of receipt of application money. Okay. Now, requirements of offer or invitation for subscription of securities on a private placement. No publication required. Okay. Filing with registrar, return of allotment. Whenever we are doing allotment, we have to file with the registrar a return on allotment. Section 39 also asked us previous approval of shareholder. Which one? Special resolution. I've told you. That's the end of the topic and the entire chapter. We will do certain question answers and we'll wrap up this entire chapter. We are not starting with a new chapter. New chapter, and the next chapter will be chapter 4, which is share capital. Okay, which will start on next Friday because Monday and Wednesday we'll have other laws. Thank you. So let us do some questions. Yeah. Have we done any of the questions at the back of the chapter? You've got the book? Okay, fine. No, we had done. On first day we had done. I recall. The criminal liability? That we have done. Though that kind of question is there, I'm just neglecting because we have done that. Okay. Write down. Examine the validity of the following case. The Articles of Association of X Limited. The Articles of Association of X Limited contained a provision that up to 4% of the issue price of the shares, may be paid, that up to 4% of the issue price of the shares may be paid as underwriting commission to the shareholders. To the underwriters, right? To the underwriters. The board of directors of X Limited decided to pay 5% underwriting commission. Okay, that is one. Take all the questions together, then we will approach. Okay. XYZ Limited, question 2, issued a prospectus inviting the public for subscription of its equity shares. Stating in it that company possesses good financial health and paying dividends to its equity shareholders. That company possesses good financial health and paying dividend to its equity shareholders consistently and regularly at 20% over the last 5 years. Consistently and regularly at 20% over the last 5 years. Is it clear? The fact was, company was running in loss since last 3 years, and it was paying dividends to its shareholders out of accumulated profits. Clear? Full stop. Mr. Amit read the prospectus and bought 500 shares from the company. Full stop. Discovering the misstatement made by the company in the prospectus, he wants to rescind the contract and claim damages from the company. Decide whether Mr. Amit will succeed. decide whether Mr. Amit will succeed. Okay. Last one question take. Also do all the questions as per like your book. Okay. Last question is, it's a direct question basically. I want to explain this concept. This is one concept which is not done in this chapter. Then entire concepts of this chapter is done. Okay. Write down. What is irregular allotment? I will make you write and explain. What is irregular allotment? Irregular allotment. ठीक है ना? ये तीनों सवाल में पहला 2 सवाल का आंसर आप खुद से लिखिए एज अ क्लास वर्क. थर्ड सवाल मैं समझा के लिखाऊंगा और पहला 2 मैं डिस्कस कर दूंगा पहले. क्लियर है? ओके. All right. So, first two questions which I gave. The first one, it's very easy. It's saying that a company's articles of association provides that, underwriting commission should be 4% of issue price of shares, and the board of directors go ultra vires because they are going beyond the powers given in the articles. So, and they are giving or deciding to pay 5% as underwriting commission, and if we go by the Companies Act rules, we see that the rules 14 of Companies Act, of course the rule number is not that necessary, the rule is more important, that the rate of commission paid or agreed to be paid shall not exceed, in case of shares, 5% or of the issue price of the share, or the rate authorized by the articles, whichever is less. Since here 4% is the rate authorized by articles which is less, we shall not exceed 4%. So the decision to pay 5% underwriting commission by the board is invalid. Are you getting me? So that is invalid. Question number 1's answer should be as small as that, as to the point as that. Okay. Now coming to the second question, which is a bigger question. The second question states that XYZ Limited issued a prospectus inviting the public for subscriptions of its equity shares, stating that the company possesses good financial health and it's giving dividend to equity shareholder consistently for the last 5 years at the rate of 20%. I had taken this example verbally also while explaining you misstatement in prospectus. I said a company giving dividend necessarily doesn't mean it's making profits. Even if it's making losses, it can pay dividends out of its reserves, and if it writes so and does not write it's making losses, it's misrepresentation and misstatement. Are you getting me? So see here the similar kind of case is given. Then they say the fact was company was running in a loss since the last 3 years. It was paying dividend out of reserves or accumulated profits. Mr. A read the prospectus and bought 500 shares. Lag gaya chuna. Discovering the misstatement made by the company in the prospectus, he wants to rescind the contract and claim damages from the company. Will he be able? Yes, section 35, civil liability of a company. You recall? He can claim damage not under 34 and not under any other section, but only civil liability. The loss suffered by him on account of shares purchased by reading the prospectus. Are you getting me? Are you getting me? So you have to write provision of section 35, and the enabling provision through which he can file a lawsuit is section 37, if you recall. Are you getting me? Okay? Is it clear? So how will you present the answer? First you will write provision of section 35 and 37. Then you will talk about the facts of the case. Then you will talk about the conclusion. Thus Mr. A can rescind the contract and claim damages from the company. Is it clear? Coming to the third and the last question, which I said I'll dictate and explain. First let me explain and then I'll dictate to you, and then we'll be done with today's class. Okay. The last question asked was, what is an irregular allotment? Let me tell you, any allotment which is not regular is an irregular allotment. Now what is not a regular allotment, that needs to be explained. So for any allotment to happen, section 23, section 26, section 39, section 40 shall be met or not met. The provisions of this section, once complied with and met, becomes regular allotment, makes the allotment a regular one. If we violate, even if we violate any one or more of these sections, it will be termed as a irregular allotment. Are you getting me? So what of section 23? So suppose a company fails to issue prospectus. So all the company going for public offer must issue prospectus is a requirement of section 23 only. Then what are the matters to be included in a prospectus? It is a matter of section 26 only. Are you getting me? And minimum subscription, minimum application is a matter of section 39. Minimum amount receivable on application is also a part of section 39. In public issue, approval for listing. In public issue, approval for listing with a stock exchange is a requirement of section 40. Escrow account is a section 40. So all the conditions which are slated in section 23, 26, 39, and 40 once met, it is a regular allotment, otherwise it is a, got it? So let us write, an allotment of shares, an allotment of shares is deemed to be irregular, when it has been made by a company in violation of section 23, 26, 39 and 40. An allotment of shares is deemed to be irregular when it has been made by a company in violation of section 23, 26, 39 and 40. Okay? Irregular allotment therefore arises in the following cases. Irregular allotment therefore arises in a ठीक है. Number 1 क्या होगा? Where company does not issue a prospectus, section 23. Bracket में section 23. Number 2, where matters to be included in a prospectus not included, section 26. Where matters to be included in a prospectus are not included, section 26. Getting me? Where prospectus has not been filed with registrar for registration, this is also section 26. If you recall, section 26 asks that prospectus shall be filed with the registrar. Recall? Within 90 days from the issue. Are you getting it? Bracket में section 26. Number 4, where the minimum subscription as prescribed in the prospectus, has not been received. Bracket में section 39. Number 5, where minimum amount receivable on application is less than the amount prescribed bracket में section 39. And lastly, where approval for listing is not taken from a recognized stock exchange, bracket में section 40. Last एक लिख लो. Last, where a separate bank account with a scheduled bank is not maintained for receipt of share application money, securities application money. ब्रैकेट में सेक्शन 40, जिसको हम लोग क्या बोलते हैं, एस्क्रो अकाउंट. ठीक है. That concludes our class for the day. That concludes our effort for the day. We are meeting on Monday as usual, 5:30. Thank you. Any query?